Today, we will talk about how to declare yourself bankrupt. Let's have a look at the details. Filing for bankruptcy is the process of requesting that a legal court releases you from your obligations to your creditors. Individuals or married couples will typically file for either Chapter 7, Chapter 11, or Chapter 13 bankruptcy. The most common reasons for declaring bankruptcy involve costly personal problems like losing a job, going through a divorce, or coping with a serious illness/injury. There is nothing shameful or irresponsible about having to declare bankruptcy, though it can have lasting implications on your credit. There are also a number of options available that may be able to help you avoid declaring bankruptcy. Learning how to evaluate your options and declare yourself bankrupt may help relieve some of your financial obligations, depending on the nature of your debts. The first step is evaluating your options. Consider hiring an attorney. If your debt is forcing you to file for bankruptcy, you may not be thinking about hiring a lawyer. However, bankruptcy laws are very complex, and any error or misinterpretation of the law on your part could affect your rights in bankruptcy court. You can find bankruptcy lawyers in your area by searching online, in the phone book, or by using the American Bar Association's Find Legal Help website. Distinguish between types of debt. Bankruptcy is a sound legal option if you absolutely cannot escape your debt. However, not all debts are covered by bankruptcy laws, and some debts may remain with you even if you successfully file for bankruptcy. Determine if you're eligible for discharge. In the United States, there are limits to how often an individual or a married couple can file for bankruptcy. This is to prevent the deliberate misuse of money and to ensure that those who are actually burdened with financial problems can find ways to escape their debt. Understand the types of bankruptcy. The three most common types of bankruptcy an individual or married couple will file for are Chapter 7, Chapter 11, and Chapter 13. Before you can file for bankruptcy, you'll need to decide which chapter you'll file, as each chapter has its own forms and proceedings. The second step is beginning your bankruptcy proceedings. Attend credit counseling. Under current U.S. laws, anyone seeking to file a petition for bankruptcy must attend credit counseling through a U.S. trustee program before being able to proceed. File Form B-101. Once you've completed the required credit counseling, you may complete and file Form B-101, the voluntary petition for individuals filing for bankruptcy. Complete and submit Form 121. In addition to Form B-101, you will need to complete and file Form 121, the statement about your Social Security numbers. This form provides the court with your Social Security number or Federal Individual Taxpayer ID number. Provide additional information. The third step is filing for specific chapters of bankruptcy. Complete requirements for Chapter 7. All forms for Chapter 7 bankruptcy proceedings can be found on the U.S. Court's website under Bankruptcy Forms. Fulfill requirements for Chapter 11. Chapter 11 bankruptcy has additional requirements and forms which must be completed. Complete the requirements for Chapter 13. Attend a post-filing debtor education course. In addition to the pre-bankruptcy credit counseling session, anyone filing for bankruptcy in any chapter must also complete a post-filing debtor education course. This session will cover fiscal responsibility topics, including developing a budget, managing your money, and using credit with caution. Await a ruling. Once you have paid all court fees and met all of the requirements, including completion of all necessary forms and attendance in counseling/courses in bankruptcy and financial management, you will await a decision. Thanks for watching this video. Please don't forget to like and subscribe to our channel if you like our videos.